press hard and we get through the fire. Got the edge and we're taking it higher. Reaching for the ages, and we got it all. We have power.
Welcome back to Made for More. I am Holly J. Moore. Lucky you, this is one of those special episodes where I'm just going to riff on something legal that's been on my mind lately. So let's talk about restraining orders today. Domestic violence restraining orders. This is a little bit, I feel like a lot of things I talk about are controversial because I generally have sort of controversial views on them. Domestic violence is a very real thing, and it's terrifying and scary, and there is a thing, you know, there are dynamics in relationships that are more prone to abuse than not. But over the course of my career of almost 20 years now doing family law, being a family law attorney, and I worked in family law for actually 5 years before that as a law clerk, it's actually pretty rare that I've seen a case where it's domestic violence like what you might be thinking of when you hear that term. And so most of my career has been defending frivolous requests for domestic violence restraining orders. And so that's kind of that's where I'm coming from. And I just want you guys to know that off the bat is abusive relationships are absolutely terrible, and I do not condone that whatsoever. But the standards and the legalities that California has set forth have made it so that it is so easy to get a domestic violence restraining order for strategic purposes, not for safety purposes, not for feeling mentally, emotionally, or physically safe purposes, but for strategic purposes. And that really chaps my hide. So, filings of requests for domestic violence restraining orders, I might refer to them as DVROs. It's the acronym that we use. Whoops. So filings for DVROs are up. In fact, during COVID, we saw a 200% increase in these filings. Now, I'm not going to talk about that because that could be a different thing. But overall, in general, these types of filings are up. Why are they up? Well, I think because, one, it's a really quick way for the lawyer to make a lot of money. Just to be totally honest with you, it has to go to trial within 21 days. So first of all, client hires you. You've got to fill out a big packet of papers. That's expensive. Then it has to go to trial within 21 days. Trials are expensive. So it's a very quick way for lawyers to make a buck. And I don't mean to sell out my colleagues, but I don't think that's right, for one, because what some lawyers in our community are known to do is really sort of pull facts out of the client that they could then say are domestic violence. And I don't believe in that. So it's a way for a lawyer to make a lot of money up front. Two, it gives the person that received the restraining order, the protected party, it gives them a leg up. It gives them a leg up with payment of debts. It gives them a leg up with custody. It usually gives them a leg up with possession of property. And it gives them a leg up as far as how the judge views the character of each of the parties, which is always at issue because how the judge views the credibility and the character of the parties is going to inform everything the judge does on that case. So there's a lot of incentive to want to say that there's been domestic violence in a relationship and to get a domestic violence restraining order. The other thing to recognize is that, think about for a second if you were the judge and you are presented paperwork that has all these allegations in them. And as the judge, you're like, these allegations seem kind of flimsy, but what if they're not? And if they're not flimsy and they're real, and I don't issue this restraining order, and something happens, and I didn't issue the restraining order, that's going to be on me, the judge. So there's a lot of pressure on judges to issue these restraining orders like on a thread of evidence. What you should also know is when, particularly in Riverside County, counties sometimes do this different, but in a lot of counties, Riverside County being one of them, One person submits their paperwork, and without any paperwork from the other person, without the other person's side of the story, the judge decides whether or not to issue or to grant or deny that restraining order. So just imagine that. They only have one set of facts, and they are deciding on one set of facts. Not having ever talked to the other person about their side of the story, they're deciding whether or not to issue that restraining order. Now, that's why it goes to trial in 21 days, because then at trial, that's where both people are allowed to tell their side of the story. But here's the real kicker. This is what is so devastating to a lot of people, is if the judge grants that temporary restraining order, because keep in mind, the other person's side was never known, never asked, never known, never presented to the judge. If that judge grants that restraining order, a lot of times they grant no visitation to the kids. So here you are going along merrily thinking everything is fine. The other party decides they're going to try their hand at this whole restraining order strategy. They file that restraining order. It's granted. Boom. Suddenly you have zero contact with your child or children for 3 weeks. Zero phone contact, zero physical contact, like zero contact. And that is really devastating to a lot of people, as you can probably imagine if you're a parent. So that's sort of the lay of the land on how restraining orders are granted in a case. In terms of the legality of these things, one, the threshold is so unbelievably low. I think the general public, when they hear a domestic violence or hear restraining order, you're automatically thinking physical abuse, which is terrible. You should get a restraining order if there's physical abuse involved. But you're automatically, immediately thinking this is something pretty egregious. What you're probably not thinking is, if you text your spouse 10 times in a day saying, I love you, can we get back together? Can we talk? I want to work on our relationship. Please call me back. That can be grounds for a restraining order. I know, it's shocking. It's shocking. To me it is. It should be to you too. Because you're talking about a person that you've been in a long-term relationship with. You're talking about somebody that you're married to or have been in a romantic relationship with. And the state of the law says if it interrupts your peace of mind, that is grounds for a restraining order. So if someone that you just broke up with is reaching out to you like 5 or 10 times in a day in a loving manner, and that is interfering with your peace of mind, that is grounds for a restraining order in California. If the restraining order is granted, there is what we call the 3044 presumption. Now, that's just legal mumbo jumbo for saying if there's a restraining order granted in a case, the judge automatically has to think. The law says the judge has to think that they shouldn't have the kids. Now, you can overcome that presumption with certain things, but just imagine, if there's a restraining order granted against you, you are now no longer starting on a level playing field. You are now starting down here and the other party is up here when it comes to the judge deciding when the kids are how much time the kids are going to spend with you, when, where, and how all that's going to work with relation to the kids. So it's a terrible position to be in with regard to trying to get custody and visitation. In many restraining order cases, there's either no visitation granted or there's supervised visitation. So what supervised visitation means is this kid that you raised for 5, 10, 15 years that you presumably were a really good parent to, now suddenly you are not allowed to be around that child without a professional there watching every move you make, and reporting on it, writing it down, making a report, sending it to the court. How humiliating and demeaning is that? Again, I'm not taking away from the fact that there are cases out there that require that. And thank God in those cases we are protecting those kids and we're getting the supervised visitation. But 90% of the cases that I see in my law firm, it's not right. This domestic violence is used as a strategy. So just super important to keep in mind how low the standard is. There doesn't have to be any physical abuse ever. There doesn't even have to be any emotional abuse. Now, another thing that's up and coming is financial abuse, where if you don't, I've seen some cases where it's like in these particular cases, I don't mean to stereotype, but these particular cases, husband tells wife, please don't spend the money. I'm going to take your name off the bank account if you spend any more money because we don't have the money. Wife files a domestic violence restraining order claiming financial abuse. You guys, it's just out of control. It's out of control because the standards are so low. So once it goes to trial in 21 days, then that's both parties' chance to present evidence. Evidence can be, everyone always says, well, it's he said, she said. Well, testimony is evidence. So one person says their side of the story, that is evidence. People always think that's not evidence, but testimony is evidence. Text messages, social media posts, video recordings. We're seeing a lot of that nowadays. Things like that. All of that is evidence that can be brought in support or to defend your restraining order. Here's what I would tell you if you are concerned that you are with someone who could possibly try to use domestic violence as a strategy. Protect yourself at all costs. Stay away from that person physically. If you are sort of the mindset that, yes, this other person is going to do whatever they need to do to keep the kids away from me, to try and get a leg up in the legal proceedings, move out of the house. Just move out. Distance yourself physically from them. That's one of the best things you can do. Don't worry about any sort of myths you've heard about abandoning the home. That doesn't exist in California. If you move out of the house, you don't lose any financial interest in the home. Just please distance yourself from that person. The other thing is be very mindful of your communication with this person. If you're going to communicate with them, one, make sure that it's not harassing in any way. And keep in mind, even if it's a loving communication, but you're doing it 10 times in a day, that can be considered harassing. So keep in mind the tone of your communication, keep in mind the frequency of your communication, and make sure it's just always of the utmost respectful, polite, reasonable communication. One suggestion that I actually learned from a client is anything that he's communicating to the other party, he puts it into ChatGPT and says, please make sure this is reasonable and polite and nice and not going to expose me for any sort of domestic violence liability. So I think that's a really good tip. So please just be aware that this domestic violence thing in California is most often used as a strategy, and you need to be aware of that so that you can protect yourself. See you on the next one. A prenuptial agreement, or sometimes called a premarital agreement, is an agreement that two parties enter into before they get married that basically chooses to deviate from state law. It assigns rights and responsibilities regarding assets and debts that are acquired during the marriage. Some common misconceptions about prenups are, one, that they basically doom the marriage to failure, or that it's really planning to divorce, and neither of those things are true. But the real value of a prenup is talking about and creating rules around how the things that you acquire during the marriage are going to be characterized. A prenup can protect things like art collections, real estate portfolios, businesses, all those types of assets. The ideal timeline to get a prenup is not 2 weeks before the wedding. The final version of a prenup has to be presented to the parties 7 days before they actually sign it. So there's like a 7-day waiting period. As soon as you get engaged, you should seek a lawyer's advice and counsel on a prenup and start the process then, because the closer the prenup is signed to the wedding, the more likely that the court is going to think there was some sort of duress involved in that person signing it, and they have to prove that the prenup was signed voluntarily in order for them to be enforced. At Moore Family Law Group, we represent a lot of high-profile people, celebrities, professional athletes, business tycoons. If you already have a lot of assets, or you think you're going to be acquiring a lot of assets during your marriage, we are the best ones to protect that for you and help you make your marriage stronger. Call Moore Family Law Group today.